to the Minister of Labour and ask, is it government policy for the 90-day scheme to be the default provision in all new employment agreements?
The Honourable Kate Wilkinson.
Mr Speaker, no.
The Honourable Trevor Mallard.
Supplementary question. Does the government agree with Chief Judge Colgan, who said in paragraph 48 of his judgment in the Smith 90-day case that sections 67A and 67B removes access to justice?
The Honourable Kate Wilkinson.
Mr Speaker, I agree with the judge's judgment that actually shows that the law is working and that there are protections in place for employees that may have been treated badly.
Point of order, the Honourable Trevor Mallard.
Mr Speaker, it was a very specific question about a specific section of the judgment which the Minister has read, and it goes to the question of those clauses removing access to justice. And the Minister did not address that question.
The Honourable Simon Powell.
It may well be that we would need to have clarified at this point whether or not it's appropriate for a minister to be expressing a view, either an agreement or disagreement with a judgment of the court, sir.
Order. To me, to the Speaker, that is a matter, so long as the court is not being maligned, it is a matter for the Minister to assess that, and it would be perfectly proper for a Minister to tell the House in her view or his view that it wasn't appropriate to comment on a judge's ruling or decision or comment. That would be a perfectly appropriate answer. But where I think the Honourable Trevor Mallard does have a point, while he cannot expect the Minister to say yes or no whether she agrees with the Minister's particular comment, some reference to the part of the judge's statement that the member was referring to would be helpful, because either to say that the Minister is not prepared to comment on it, but to ignore that part of the question totally, because there was only one part to the question, and I don't think it's reasonable to ignore it totally. I'd ask the Honourable Kate Wilkinson to reply, and it may be that in fact it's not appropriate to comment on the judge's comment. The Honourable Kate Wilkinson.
Mr Speaker, as I said, but whilst I'm prepared to comment in a generic manner on a judgment, I'm not prepared to comment on the specifics, because it may well be that that case goes to appeal.
The Honourable Trevor Mallard.
On the question of the appeal, is it the government's intention to appeal that part of the judgment which says in paragraph 48 that sections 67A and 67B that she introduced remove access to justice?
The Honourable Kate Wilkinson.
Mr Speaker, at this stage we have no current intentions to appeal the decision, and nor were we a party to the proceedings.
David Bennett.
Supplementary question to the Minister of Labour. What reports has she seen on how trial periods work overseas?
The Honourable Kate Wilkinson.
Mr Speaker, in the United Kingdom they have a very successful mandatory period of a year, and in Australia they also have a year for small businesses and 6 months for everyone else. It's worth noting the Australian CTU support a 90-day grievance-free period just like ours, and I look forward to the day the New Zealand unions catch up with the rest of the world.
The Honourable Trevor Mallard.
Is she satisfied to be the Minister in charge of a piece of legislation that a Chief Judge says removes access to justice?
The Honourable Kate Wilkinson.
Mr Speaker, I am satisfied that the 90-day trial as introduced last year is working well. It does have protections, and we always intended that it has protections to avoid any exploitation and abuse.
The Honourable Trevor Mallard.
Does she agree with the Chief Judge when he said her legislation removes access to justice?
The Honourable Kate Wilkinson.
Mr Speaker, I agree generically with what the judge has said, is that the legislation has protections. Those protections worked, and the judge found in favour of the employee.
Question number 6, Hilary Calvert.